Hello everyone, thank you for staying with us. If you've just joined us, it's a very good afternoon. Another twist of events in the Thabo Bester matter. Dr Nandipha Magudumana, Bester's alleged partner and accomplice, is heading to court over her arrest in Tanzania. Magudumana wants her arrest declared wrongful and unlawful. The pair was nabbed in Tanzania last month after fleeing the country following a picture which surfaced on social media showing Bester on a shopping trip with Magudumana. Bester had escaped the Mangawong Correctional Centre, in Bloemfontein in May last year after faking his own death. Magudumana is facing, among others, charges of assisting an inmate to escape from lawful custody and defeating the ends of justice. She's filed urgent papers in the High Court in Bloemfontein. The matter is expected to be heard on the 25th of May. Legal analyst Mpumelelo Zikalala joins us now for more on that issue. Mpumelelo, I appreciate your time this afternoon. It seemed a pretty clear-cut case when we look at it, but obviously Magudumana knows something that we don't, or does she?
Definitely, and that's something that she knows. She's saying, no, actually you are violating my rights. I shouldn't even be here. On that basis, I'm going to go to court on an urgent basis and say to the court, can you please set aside all the papers that have allowed me or that have authorized the law enforcement agencies to arrest me, to put me into where I am now. But that might face a few challenges. Firstly, remember that you're going to court on an urgent basis, so you must be able to prove that there's a right that you want to protect. You are going to suffer irreparable harm. There are no other alternative remedies that you have, and on a balance of probabilities, you're going to win this matter. Now, on that basis, I do not think on the irreparable harm part, she's going to be successful, or it's going to be very hard to be able to prove it, because she's already in jail and has been for quite some time. Secondly, there are other alternative remedies. That is why we have bail applications, for example, to allow a person to go out temporarily while they are trying to defend themselves and to gather the evidence that they might need to even challenge the manner in which they were arrested. So what's the unique point or unique circumstances that exist in this case that would warrant the court in terms of saying, we are going to grant you urgent relief and make sure that you're able to go home and be set free when you have certain or compelling evidence which is against you and which that led the law enforcement agency to bring you to court since you are charged with the charges that you are charged with.
Pumla, let's rewind a little bit and obviously explain this for the viewers that are watching at home. You suggested that there are rights that have been infringed upon. What would these rights be?
The rights would be my right to freedom, for example. I'm meant to be out there to be able to enjoy my freedom in as much as I so please. So that's the basis in which she would come to court and say, you are not supposed to detain me. By you detaining me, you're holding me against my will. I do not want to be in jail.
But surely, if I may interject, surely she's an accused, she's an accomplice to and has been abating Thabo Bester in this entire process.
Which is why I'm saying that the chances of the urgent application being successful are going to be nil to none, because there are other alternative remedies that are there. There is an appropriate manner in which this particular matter can be solved in. It does not have to be solved on an urgent basis. But what you can't ignore is that there are rights which are at stake. There are rights that may seem to be being infringed at this particular stage, but there's reason for them being infringed, and there's probably a vague explanation as to why those rights are infringed. Now, what the state is going to, when they're defending the matter, is going to say, there's a perfectly open opportunity for you to be able to protect your rights in which you have come to court and said that your rights are being infringed by applying for bail, for example, which is something that you have not done, despite being given ample opportunities to do so. You've simply chosen to abandon this process. What you have chosen, by the way, is to go through the civil route, which would then say, let's hear this matter on an urgent basis, where there is a perfectly placed legal principles and system which allows you to be able to protect your rights in an appropriate manner. So on that basis, the court will come back and say, on the basis of agency alone, without even going to the merits of whether what you are saying is true or correct or not, let's dismiss your application because it's not urgent according to us.
So let's talk about the timing. She potentially had time prior to this to have put in the application. Why would she do so at this very point?
I think I'm not privy to any of the papers that have been submitted, but one would assume that maybe there is information that she has been able to obtain. If that particular information is so incriminating that there are certain procedural aspects that were not subscribed or not complied with, maybe she would have a point. But it does not mean that the state is not going to come back and say, whatever that you want to state, whatever defense that you might have, whatever irregularities that have taken place, go and ventilate those in a criminal court and go to a civil court. Then on that basis, the state will win again in terms of saying, we're not going to release on an urgent basis because there is an appropriate remedy which is available to you, which is one of the elements that you have to prove if you go to court on an urgent basis, that there are no other alternative remedies which exist or are available to me. Hence why I've had to drop everything and come to court to be able to defend my rights.
So, in your view, the High Court is likely to throw out this application. And that being said, if that is the way the High Court does go, she still has the opportunity to refer to other courts in the same matter.
Definitely, not only other courts in terms of the civil or this application that she would have launched, she still has an opportunity of applying for bail, because bail is designed precisely for that, in terms of saying, while you are trying to fight whatever issue that is there, whether you are arrested properly, whether it's on the basis on the merits, whether there's certain procedural aspect that you're not complied with by the state, while you are trying to do that, go and deal with that while you are considered yourself to be a free man, and I say that in inverted commas. But don't come to court and expect to curtail or to short-circuit bail proceedings when those bail proceedings or bail application or that particular opportunity was open to you within the criminal court, and you specifically chose that I'm not going to participate in it, I'm going to wait up until a later stage. Meanwhile, you knew that the only thing that you wanted was to launch an urgent application. So I'm saying on that basis, the chances of this particular court bill succeeding, are they a bit slim.
Final question. Why would Dr. Magudumana not have, or rather decided not to appeal for bail?
Initially, I thought that it was a strategy of saying, I want to hear what the state has got. Probably when the other four accused are applying for bail, the state is going to have to advance some sort of arguments and be able to disclose the facts or the evidence in which they are relying on. And only after that she has heard of that, then she can be able to conclude or draft a bail application so that it's able to meet the requirements as per the Criminal Procedure Act, which basically means show us that the exceptional circumstances that exist in this matter. And one of those exceptional circumstances would be you have investigated the matter so extensively that there are no witnesses in which I'm going to interfere with. You've collected your evidence as well and dusted. Hence, you're even able to get a person to go into the witness box and testify against us. I don't even know the manner in which you are doing that investigation. So don't deprive my rights. Let me be free because I'm still considered innocent as a right which is afforded to me by the Constitution. I would have thought that would have been the strategy. But this one, I must say, I'm a bit also surprised as to why you would launch an application which is similar to this matter, especially when there's no agency that there is. Maybe if it was launched 2 or 3 days after arrest, then I would have understood. But for now, there's a huge amount of time that has lapsed since her arrest up until now, which is the harm, the irreparable harm that she's suffering. If you can't prove those elements, which is the first leg and the most important leg of in any urgent application, the court will not even deal with the merits of the second leg of assessing whether is there anything that needs to be protected by the courts.
Dr. Nandipha Magudumana wants her arrest in Tanzania declared wrongful and unlawful. That conversation with legal analyst Mpumelelo Zikalala, citing that her chances, according to him, pretty slim.